The first thing I saw was the auction sign nailed to my front gate. Behind it, 3 black SUVs sat in my gravel drive. A realtor pointed at my horse barn like she was selling a model home. 2 buyers took pictures near my pasture fence. And beside them stood Martin Kale, the president of the neighboring HOA, smiling like the ranch already belonged to him. I got out of my truck and asked what he was doing on my land. He adjusted his sunglasses and said, "You mean former land?" Then he handed me a folder claiming my family ranch had been auctioned for unpaid HOA assessments and land use violations. The problem was simple. I had never belonged to that HOA. My ranch existed before their subdivision, before their bylaws, before their board meetings, and before Martin learned how to weaponize the word compliance. Then I opened the folder. Inside was a photocopied deed with my father's signature at the bottom. But my father had been dead for 6 years. That was when my anger went cold. Martin had not just crossed a fence line. He had walked onto my family's land with buyers, paperwork, and a forged signature. 3 months later, he would walk into county court expecting a quiet title victory. Instead, the judge opened the original deed and asked why my name was still recorded as the lawful owner. I was not the kind of person who looked for fights. Most of my life, I only wanted the quiet routine my parents had built before me. I woke before sunrise, checked the fence line, fed the horses, and kept the old gravel road open for my truck. The ranch was not fancy. It was cedar posts, red dirt, patched barn doors, and pasture land my family had protected for generations. My grandfather bought the first section when this county was still mostly cattle roads and oak trees. My father added more land piece by piece. He used to point at the old survey marker near the southern oak and say, "A fence can rot, a man can lie, but a recorded deed can outlive both." For years, nobody bothered us. Then the subdivision came. At first, I ignored it. People needed homes. Families moved in. Kids rode bikes near the cul-de-sacs. What bothered me was the way the HOA board started looking at my ranch like unfinished business. They complained about my barn, my tractor, the dust from my private road, the smell of horses after rain, and grass that had been pasture long before their lawns existed. Every time they sent a letter, I replied the same way. I was not a member. My land was separate. My deed came first. Their rules stopped at their recorded boundary. Then Martin Kale became HOA president. At meetings, he called my ranch an obstacle to community expansion. In emails, he called it underutilized open land. To him, the ranch was empty space. To me, it was my father's hands in every repaired gate, my mother's garden behind the house, and the last place where my family still felt alive. So when the first official notice arrived, I did not laugh. It called my ranch undeveloped association expansion land. That was when I realized the HOA was no longer asking me to comply. They were preparing to erase me. The first notice was ridiculous. It said I owed the HOA $12,000 for unpaid assessments, nuisance violations, and failure to maintain shared open space. I read it twice at my kitchen table. There was my parcel number, my ranch name, and Martin Kale's signature at the bottom. I emailed the HOA that same day and told them they had no authority over my land. Martin replied with one sentence: "Your refusal to cooperate will be considered evidence of non-compliance." After that, the letters came faster. They fined me for my tractor, my barn color, horse odor after rain, and excessive pasture growth, as if a pasture was supposed to look like a golf course. Then, one morning, I found 3 men in orange vests inside my fence line. They worked for Northridge Communities, a developer. One of them told me they were mapping future equestrian lots. I told them they were trespassing. He checked his clipboard and said, "According to the HOA, this land is pending transfer." That was when it stopped feeling like harassment and started feeling like theft. 2 weeks later, a homeowner slipped me a copy of a closed HOA meeting packet. My ranch was shaded green on their map and labeled Phase 4 Expansion. Inside that packet was the auction notice. The HOA claimed it could sell my ranch because I had failed to pay association debt. That afternoon, I drove to my gate and found the auction sign already nailed there. Martin stood in my driveway with buyers and a realtor. He said, "You should start removing personal items before this becomes embarrassing." I wanted to rip the sign down. Instead, I took out my phone and recorded everything. Then I asked, "Show me where I agreed to join your HOA." His smile changed. He handed me a folder. Inside was a photocopied deed with my father's signature, a signature dated 4 years after his funeral. I did not argue with Martin after that. I did not tear down the auction sign. I did not shout at the realtor or threaten the buyers walking near my pasture fence. I just kept recording. I recorded the sign, the SUVs, the faces, the license plates, and Martin saying the land was already pending transfer. Then I saved every file in 3 different places. That night, I spread everything across my kitchen table. The HOA notices, the auction packet, the Phase 4 expansion, map, the fines, the emails, the photocopied deed. Then I opened my father's old fireproof lockbox. Inside were the papers he had always told me mattered more than any fence, the original deed, the old survey, tax records, easement documents, and a yellowed plat map with my grandfather's notes in the margins. I compared the real deed to Martin's copy. The legal description did not match. The boundary language had been shortened, the southern oak marker was missing, the exemption clause was gone, and my father's signature looked too clean, like it had been pasted onto the page. The next morning, I went to the county clerk's office and asked for certified copies of every document tied to my parcel. That was when the clerk found a corrective community declaration filed by the HOA 4 months earlier. It claimed my ranch had always been future association common land. But there was no purchase agreement, no membership form, no valid lien, no signature from me. I hired a licensed surveyor that week. By sunset, he confirmed my ranch had never been part of the subdivision. The HOA boundary stopped across the county road. Even better, the gravel road they called association access was actually my recorded private farm easement. Then I called a real estate attorney. He reviewed the forged deed and asked where Martin could have gotten my father's signature. That night, I searched through Dad's old permit folder, and there it was. A barn roof repair permit with the exact same signature. Same angle, same pressure, same tiny break in the letter B. Someone had copied my dead father's signature from a county permit and used it to sell my ranch. That was no longer an HOA dispute. That was evidence. The legal twist was sitting in one line of my original deed. The ranch was an independent agricultural parcel, exempt from any future HOA covenant, restriction, or subdivision agreement, unless the lawful owner signed separate written consent. My family never signed one. I never signed one. That meant their authority stopped before it ever reached my gate. Then the survey came back. The county road separated my ranch from the subdivision. The HOA boundary was recorded on their own plat map. They had simply colored past it and hoped nobody would check. The easement made it worse. The legal twist was sitting in one line of my original deed. My attorney found it under the property description. The ranch was an independent agricultural parcel, exempt from any future covenant, restriction, association control, or subdivision agreement, unless the lawful owner signed separate written consent. My family never signed one. I never signed one. That meant the HOA could send notices, invent fines, color maps, and call my pasture Phase 4 expansion. But legally, their authority stopped before it reached my gate. Then the survey came back. The county road separated my ranch from the subdivision. The HOA boundary was not unclear. It was recorded on their own plat map. They had simply colored past it and hoped nobody would check. The easement made it worse. The gravel road they called association access was actually my recorded private farm easement, created long before the HOA existed. So they had not just tried to sell my land. They had tried to sell access they did not control. My attorney sent a demand letter ordering the HOA, the auction company, and North Ridge communities to cancel the auction, remove every listing, stop entering my land, and preserve all records. Martin's attorney called it a misunderstanding of community planning authority. But the forged deed had been attached to their county filing. That meant they had used my dead father's copied signature in an official record. After that, the realtor removed the listing, and the developer stopped sending workers. But the HOA still filed in county court, asking a judge to confirm their right to enforce assessments and proceed with the transfer. They thought court would scare me. What they did not know was that my attorney had already subpoenaed the HOA's emails. And buried in those records was one message from Martin to another board member. We need to move before he realizes the old deed excludes him from the HOA. That sentence changed everything, because it proved Martin knew the truth before the auction sign ever touched my gate. By the time we walked into county court, the HOA was no longer treating it like a neighborhood dispute. Martin sat behind his attorney in a navy suit, staring straight ahead like confidence could replace evidence. My attorney placed four things on the table: the original deed, the certified survey, the recorded easement, and the HOA email where Martin admitted he knew the old deed excluded me from the association. The judge read quietly. Then he looked at the HOA's attorney and asked, "Where is the signed consent bringing this parcel into the association?" The attorney started talking about community planning and future development. The judge stopped him. "I asked for the signed consent. There was none." Then my surveyor explained the boundary. The county road separated my ranch from the subdivision. The HOA plat stopped before my land. After that, the county clerk's certified records showed no valid lien, no transfer, no membership agreement, and no assessment authority over my parcel. Then came the forged deed. My attorney placed my father's barn repair permit beside the HOA's transfer document. The signatures matched too perfectly. Same angle, same broken line in the letter B. The courtroom went silent. The judge turned toward Martin. "You attempted to auction property based on a document signed by a man who was already deceased?" Martin's attorney stood up fast. "But the damage was done." The judge suspended the auction immediately and ordered the HOA to preserve all emails, meeting minutes, contracts, maps, and financial records related to my ranch. The sheriff's civil division took a report for trespass. Code enforcement opened a file on North Ridge's unauthorized survey work, and the county land records office flagged the corrective declaration for review. For the first time since the auction sign appeared on my gate, Martin did not look powerful. He looked trapped, because now every lie had a file number. The auction was canceled before the end of the week. Not postponed. Canceled. The court confirmed that the ranch belonged to me, that the HOA had no authority over my land, and that every fine, assessment, notice, and transfer claim they had issued against my parcel was invalid. The judge ordered the HOA to pay my attorney fees, the survey cost, the county filing corrections, and the damage caused by clouding my title. Northridge Communities pulled out of the deal the same day and sent its own legal demand to the HOA for providing false ownership information. The auction company terminated its contract with the board. The County Land Records Office removed the corrective declaration from my parcel history, and Martin Cale resigned 2 days before the emergency HOA meeting. He did not apologize to me. He did not have to. Watching him sit silently while homeowners demanded to know why their dues were about to pay for his arrogance was enough. A month later, I stood at my front gate with a claw hammer and pulled the auction sign off the cedar post. Under it, the old Brennan family ranch plate was still there, scratched but readable. I replaced the bent nails, installed a new camera, and added one more sign beside the gate. Private property, recorded farm easement, no HOA authority. Then I walked back toward the house, past the barn, past my mother's wild garden, past the pasture my father had fought to keep intact. I did not win because I yelled louder. I won because I kept the deed, saved the emails, recorded the trespass, hired the right people, and refused to let a board with fake authority rewrite my family's history. So, if this story made you think about how far some HOAs will go when nobody checks the paperwork, leave a comment with your thoughts. Like the video, share it with someone who owns land, and subscribe for more stories where evidence, patience, and the law finally turn the tables.